Hello everyone, my name is Maame Efua Addadzi-Koom. I'm an assistant lecturer at the Faculty of Law, Kwame Nkrumah University of Science and Technology, Kumasi, Ghana, and I'll be making a presentation on a paper titled State Responsibility for Domestic Violence in International Law, the ECOWAS Community Court of Justice and the Due Diligence Standard. Now this paper was triggered by a decision by the ECOWAS court, which was actually the first decision by the court on domestic violence. The case was applauded for a lot of reasons. For the fact that it held the states accountable for not ensuring that its citizen, which was a victim for domestic violence, had access to justice and fair trial. But what I found intriguing about the case was that even though the case was a domestic violence case, and yes, the state was held accountable for not ensuring that the victim had fair trial, the state was not held accountable for domestic violence or any action that discriminated against gender. And so I started wondering what happened? What's the reason of the courts? Why did the courts hold the state accountable for one part and not the other? And that's what brought about this paper. So I have read and done the research, and I'm here to tell you why it was so, and essentially to try and unravel and ascertain the burgeoning jurisprudence of the ECOWAS court regarding the application of due diligence in domestic violence cases in international law. So before I get to the Marisande case itself, which is the core of the case, I'll just talk briefly about domestic violence and what it means in international law, a little about state responsibility in international law, and then the due diligence standard itself in international law, and then I'll bring it all together and talk about it in relation to the Marisande case. So domestic violence is ordinarily something that was perceived for a very long time as being a private thing occurring within the private sphere, and that even national laws were not intervening in domestic violence because it occurs within the private sphere. Now we move way beyond that, and now there are national laws on domestic violence. But then to bring it to the international level was another thing that required that a lot of reasoning and a lot of good reasons be given for plunging domestic violence in international law. And one of the ways was scholars try to relabel domestic violence so that it does not look just as a domestic criminal justice issue, but as an international human rights issue that deserves international attention. And so some people try to call it torture, some scholars call it private torture, some scholars call it terrorism, others call it patriarchal terrorism. There are many of them. And so essentially all of these were to play up the need to bring domestic violence within the international plane. And so the domestic violence being in the international plane started actually progressing in the early 1990s, where in 1993, for example, the General Recommendation 19 of CEDAW stated that the Convention on the Elimination of All Violence Against Women, which is CEDAW, was applicable to violence against women both within the public and the private setting. So that's the first thing, so that domestic violence being a form of violence against women, though occurring in private, would have CEDAW, that's the convention, applying to it. And then in that same 1993, the UN first appointed a special rapporteur on violence against women, which was Ms. Radhika Kumaraswamy, and she presented her first report in 1996 on her findings on domestic violence and its consequences and its causes as well as its consequences. Then we also have in 1995 where there's a Beijing Platform for Action that also brought all states together to take measures, political, legal, administrative, all measures that are appropriate to ensure that there is the elimination of violence against women. And so these measures on the international plane has eventually brought domestic violence in international law, and CEDAW itself has the CEDAW committee has itself decided on cases that were bordering on domestic violence. I would just mention one of them. We have AT and Hungary, in which AT was subjected to violence by her husband for about 4 years. She and her 2 kids with the husband were subjected to violence by the husband. The husband even threatened to rape them and all of that. But then, so the issue went to the CEDAW committee after she exhausted all the local remedies, which is a requirement to bring a case before the CEDAW committee. And so the CEDAW committee essentially found that Hungarian legal system was not comprehensive enough to support her and to prevent and to protect her against the violence that she was going through. And so the state of Hungary was found liable for not putting in all the appropriate measures to ensure that the AT did not suffer the violence that she suffered. Then there was also this case, Gorky versus Austria, which also went before the CEDAW committee. In this case, the victim actually died. It was a series of violence as perpetrated by her husband, and once she made reports to the police. At one time, the police wanted to pursue it, but she reclined, and she said that she didn't want the state interfering in her private matter and all of that. But then on the day she died, she made an emergency call to the police, but there was no patrol sent to the area. And then not long after the call, the husband shot her, and then she died. But the husband owned up 2 hours. He surrounded himself 2 hours after the shooting, and he's now on life imprisonment at a center because he had a psychological issue. And so all of these cases and all of these come together to show that domestic violence is now an international law thing. Now, state responsibility, there are 2 conditions for state responsibility under the Articles for Responsibility of States for Internationally Wrongful Acts. Now, under those articles, there are 2 conditions. The first thing is that the action either taken by the state organ or a person or group of persons should be attributable to the state. And the second thing is that the action should be a breach of international law. That's essentially state responsibility. Ordinarily, states are not responsible for the actions of individuals except where that individual is acting under the direction of the state. And if it involves a state official, the state official is acting in his official capacity. Even if he's acting in official capacity, but his actions are ultra vires, the state will be responsible. However, the state will not be responsible if he was acting purely in his private capacity. I think I would end here for state responsibility, and then I'll now move on to due diligence and explain it, and then I'll bring it all together. Now, due diligence is essentially premised on this basic question. Now, what is the minimum, or what measure of action or due diligence or responsibility of the state will be considered reasonable enough for the state to have satisfied its international obligations? So now in due diligence, we're looking at the reasonable minimums in trying to ascertain whether a state has complied with international obligations. And so there is a state due diligence is sometimes said to be as a matter of means and not results, because the fact that, for example, there is still domestic violence in a certain country doesn't make the state liable for domestic violence per se. But if the state has done all due diligence in exercise into preventing, protecting, prosecuting, punishing, providing reparation, these are all the 5 P's of due diligence. I'll take it again. 5 P's of due diligence. We have preventing, protecting against, prosecuting, punishing, and providing reparation. If the state has done due diligence in satisfying these 5 P's, then the state has exercised due diligence, irrespective of the fact that there are still some records of due diligence, domestic violence in the state. So due diligence is essentially that to make sure that states are doing their due diligence in protecting women from being violated. Now, when you put all these 3 together, that's due diligence, state responsibility, and domestic violence together. Due diligence plays a role. Three of them, which I will mention. One of them is that due diligence challenges the public-private dichotomy for domestic violence that once existed, because now due diligence is saying that you should do your minimum even if those actions are being perpetrated by non-state actors. The state should do its best to make sure that women are being protected, or victims of women generally are being protected from violence. Now, the other way in which due diligence affects domestic violence and state responsibility is that the due diligence expands state responsibility. So once upon a time, states would not be responsible for some actions by individuals unless the individual is acting under the direction of the state. Now, the state will be responsible in another way, not directly for the private actions of the individual, but indirectly for failing to prevent the conduct of the individual or failing to prosecute that individual after performing that conduct. So now, state responsibility for domestic violence in international law may not necessarily be direct unless it's a systematic form, but it's ordinarily indirect because the state failed in exercising its 5 P's to prevent, protect, prosecute, punish, provide reparation for victims of domestic violence. That's how due diligence marries domestic violence and state responsibility. Now to the Mary Sunday case. So what happened in the Mary Sunday case is that Mary Sunday is a young lady, a Nigerian, who is in a relationship with one Corporal Bangwa. I hope I got the name right. Yes. So these two are fiancé, and then they had a squabble. The squabble went physical. So in their fight, they moved from where they were into a neighbor's kitchen. Now here in the neighbor's kitchen is a boiling pot of hot oil. And so in the exchange, in the fight, the oil pours on Mary Sunday and she gets killed. She's sent to the hospital, the police come in, conduct investigations, but then there's frustration somewhere because now the officer that is in charge of the investigation dies, and after she dies, she is told that the documents are lost, so they can't proceed with the matter. So then she sends it to the ECCJ. Now, one thing with the ECCJ is that unlike most other regional platforms, you do not need to exhaust domestic remedies before you send an action to the ECCJ, that's the ECOWAS court. And so Mary Sunday goes with 2 NGOs acting on her behalf against the Republic of Nigeria. Now she brings about 4 grounds: discrimination based on gender, that her right to health was violated, that her right to work was violated, and that her right to effective remedy was also violated. Now of these 4, it was only one that a court held for Mary Sunday and granted her relief, for which they charged the state of Nigeria with 15 million naira. Now the reason of the court so it was her violation of her right to effective remedy that was granted. And for that, the reasoning of the court was that the state had a duty to ensure that they seriously investigate. Now, in prosecuting, which is one of the 5 P's of due diligence, prosecution involves that you seriously investigate the matter, thoroughly investigate. Now, from the evidence that was presented, Mary Sunday's case was not thoroughly investigated. There were bits and pieces of evidence scattered here that they could have reasonably put together to be able to gain a firm ground to prosecute the case, but that was not the case, and then they closed it with the documents are missing. And so for that, the case, the state of Nigeria was held liable for not properly investigating, properly prosecuting, and making sure that she could access a judge and access a justice system where she could be heard. Now, for the rest, she was not granted her release for a number of reasons. Now, my focus is mainly on the discrimination based on gender. Now, this is the reason that the court gave. The court gave the reason that the discrimination was not general, nor was it systematic. This was the violent act was a matter that occurred purely within the private sphere and had nothing to do with the state. Now that brings the question, so what forms of domestic violence warrant international intervention? And in the courts, even though the due diligence standard was not stated specifically in relation to the discrimination based on gender, what I gather from reading the case was that for domestic violence acts, for domestic violence acts to come up to the international level so that a state might even be directly or indirectly responsible for it, the violence must be general. So there must be a record, sort of other discriminatory acts that have occurred that the state did nothing about. or it must be systematic, and there must be a continuum. Now, this was a single one-off event, and so there was no evidence to show that, oh, the corporal had been beating her maybe not once, maybe twice, maybe 3 times. There was no evidence of that. So this was a one-off event that could have been settled at a national level. And so in reading, my time is running out for my timer, so I think I'll just round up here. But then in reading the case and analyzing in the paper that I developed out of it, one of the things I came out was that, yes, the court there are inferences of the due diligence standard, expecting the state to be responsible, especially in the issue of her right to fair trial and the right to effective remedy, but then also not making the state, not opening the floodgates for the state to be responsible for actions that they had nothing to do with, like an action that is in the private sector, an action that is not systematic in nature, an action that some individual, even though he was a corporal, acting purely in his private capacity, perpetrated against a woman, cannot be the state's fault for discriminating against gender. Gender connotes generality, and so it shows that in subsequent cases, one of the things that I realized is that in subsequent cases, for such an action to be able to for the court to actually hold a state accountable for that, then that action must be general in nature. For example, in one of the cases that is in the in cases in other regional courts that I read cases from, some of them, there was one against Maria Fernandez in Brazil, that was in the Inter-American Court of Human Rights, where in Maria's case, she indicated and she proved evidence, she gave evidence for the fact that her case was just one of a series of other systematic ways in which the state of Brazil had not given victims of women access to justice, because the state even had a very bad attitude towards victims of domestic violence. And so that's the kind of evidence that would have pushed the ECCJ, if there was, to, for example, say that, oh, then there's discrimination against gender, but there was no such evidence. So in the for subsequent persons that would want to bring cases like that to the ECCJ, they would have to do their homework well, which also comes back to one of the rapporteurs who was saying that one of the underlying principles of the due diligence is that all those measures must be based on empirical data and statistics. And so you would need to come with some hardcore evidence to prove that this state is in the business of systematically denying or not giving women access, or not exercising its due diligence to ensure that violence against women is eliminated. And also, one of the issues that also came up, one of the rapporteurs, who is called Manju, also suggested that in due diligence we should not conflict and merge due diligence into one box, but there's a need to separate what we call individual due diligence and systematic due diligence. Individual due diligence will be the due diligence that the state owes to the individual to make sure that the needs of the individual is met, and then we'll have systematic due diligence, which is the due diligence of the state to do things generally for everybody, for the citizenry and for people in this state, so that they have access to justice. So in my analyzing that to his separation with the ECCJ, I realized that you could infer from the way the ECCJ decided that they were going towards that individual due diligence, for which they were able to hold Nigeria responsible and to Mary Sunday, because she needed to access justice and the state failed her in that regard. But they were not found liable for failing their obligation to systematically ensure that exercise due diligence, because there was not even any statistics to show that, oh, this is what usually happens in Nigeria, or they have a record of not giving women who are victims of domestic violence access to justice. And so, yes, although not expressly mentioned in the decision, it was mentioned in a variant way. They used appropriate diligence when they were talking in relation to the right to health, which time will not allow me to talk about. But we are getting there, and I believe that in subsequent decisions that will be rolled out by the ECCJ, they would also try and develop the due diligence standard as it applies to domestic violence within the African context. Thank you, and any questions will be welcome for further clarification. I'll end it here.